This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.
Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. Governor Pataki's call for the impeachment of Judge Lauren Duckman has far-reaching consequences that go beyond this individual case. By threatening to oust the judge if the Commission on Judicial Conduct fails to do so, the governor undermines the ability of the judiciary to act with integrity and independence. Today we'll look at this issue with the Honorable Abraham Gurgis, Justice of the Supreme Court, Kings County, and Ronald Russo, the attorney representing Judge Duckman. Hello, Judge Gurgis.
How are you?
Hello, Ron. Ron, give us a little summary of the Duckman case and what's all the publicity go about.
Well, I must say that if you read the record, I think that the average citizen thinks what happened here, Alan, is that someone was arrested on a murder charge and they went in and he was released to go out and commit murder again. But in point of fact, this is really not a soundbite. It's a long and a complex story, but to put it into a nutshell, we're dealing with an individual by the name of Benito Oliver. He is a defendant who was arrested in the middle of December 15th, and he is held on misdemeanor charges. Initially, there was a felony charge. 4 days after his arrest, it was dismissed. And on a misdemeanor charge, he was held for 40 days. In total, he was brought before 5 judges, 13 appearances, and repeatedly, judges other than Judge Duckman inquired whether or not the district attorney was ready. And I frankly don't quite understand why, but no one has asked District Attorney Hines of Kings County why, with 500 assistants, he wasn't able to get a misdemeanor case ready for trial. And when Judge Duckman had it at the end of January and the defendant had been incarcerated 40 days on a misdemeanor, he basically said, in our constitutional system, people who are accused of crimes are presumed innocent. He has been held for long enough, and I'm going to put a reasonable bail that he can make, and he did in fact make the bail and go out.
He lowered the bail from, was it $5,000 to $2,000?
That is in fact what happened, but it's a bit more complex than that in the sense that when Oliver was first arrested, he was brought on a felony charge before Joanne Ferdinand in Kings County Criminal Court. And Judge Ferdinand was asked to set a bail of $7,500 because there was a felony charge pending and the defendant had 3 felony convictions. The judge denied the request for $7,500 bail and set bail at $3,500. 4 days later, when Oliver was brought back before another judge, again not Judge Duckman, bail was reduced by Judge Jerome Kay on his own motion when the court learned that the felony complaint had been reduced to a misdemeanor.
But of course, it resolved in Judge Duckman lowered the bail.
Correct.
Mr. Oliver went out and actually shot
Correct. What
his
happened
girlfriend,
is that what did happen
Ms.
is
Komar, and then he killed himself.
Correct.
Okay.
That was in the middle of February.
Now, Governor Pataki has called for the resignation or impeachment of your client, Judge Duckman.
That's correct.
Okay. How do you feel about that?
I think it's a total overreaction. I think it is an outrageous politicization of the judicial system. I don't have to tell you, Alan, as a trial lawyer, that this is virtually unprecedented in the history of the state.
Well, I believe the last judge was impeached over 100 years ago.
1872, for massive corruption. Estates were being given to his brother-in-law, and typically when impeachment is called for, it's that kind of concept. In the federal constitution, of course, it's called the high crimes and misdemeanors. I think it's absolutely a political football, and I think it's very unfortunate that the governor has raised the volume this way.
Judge Gurgis, can you address that issue?
Alan, I think that there's a different issue in the way I'd like to look at it. There is absolutely nothing wrong in criticizing a judge. We're not above the law, we're not above criticism, and whatever the case may be. And as a matter of fact, sometimes it's good because this issue might have raised other issues, looking for solutions, for example. A judge doesn't have a crystal ball. A judge in the criminal court, for example, people would not understand there were 313,000 arrests in New York City last year. $313,000. There's a handful of judges that handle that amount at arraignment and so forth. The information that's given to a judge is how he bases what bail should be, for example. It's given by the district attorney, it's given by probation department, and a lot of other people. In domestic relations, for example, and I looked at this issue and I was wondering, how do you solve a problem like what Judge Duckman had? Well, one of the suggestions, for example, that I'm going to be making, and you have an exclusive on it right now, is that we ought to have some kind of a psychiatrist in the courtroom that would analyze and speak to a defendant and give back a report to a judge, so a judge can at least have the information before him before he sets bail.
As to the dangerous propensity of
Now, it's very hard to predict future
isn't that
violent behavior.
Isn't that preventive detention?
We get information. We get what's called a NICIS sheet on a defendant that tells us his background, if he's whatever he's done, and we base bail or releasing the defendant on the information that's given to a judge. Now, what is the difficulty here is the public out there is given the wrong impression. The public out there feels that there's a lot of crime. They want something done about it. So when you say a judge let somebody out, well, that's headlines, and the public has the wrong information.
Okay.
And now, that's really where I see where the problem is.
Governor Pataki is saying this particular judge, I don't want this judge sitting anymore. In fact, he's saying if the Commission on Judicial Conduct doesn't remove him, I will myself commence impeachment proceedings in the state legislature.
Well, the chilling part of that upon the judiciary, and the judiciary should have the ability to not be afraid of bad publicity. Judges aren't supposed to be popular. I mean, that's very important to remember. Judges are supposed to do what's right, and that's not always popular. And so when a judge or when a governor or a mayor calls for the removal of a judge, and there really isn't a basis for it because they don't even have the information yet to really judge whether that judge or any other judge should be taken out. That is misinformation that's given to the public, and that's terrible when that misinformation is given to the public. And what effect does it have upon a judge? Judges are human beings. No judge wants to see his face on the front page of any newspaper saying he left this guy out and the guy went out and killed somebody. No judge wants to see that. However, you have to do what's right. If you have a case in front of you in which the person, for example, has no record, and you ROR him, and that person goes
released
out,
on his own recognizance,
and goes out and kills somebody, that's terrible. But the judge doesn't know that that's going to happen. He doesn't have that crystal ball. So you do it upon the information that's given to you. Very often, district attorneys don't have the information that they should give to a judge, so the judge is now making a decision on not enough information. Probation departments make mistakes.
But tell me about the governor. Does the governor have, actually, he's attacking this particular judge? Is that part of his...
Actually, if I might, Judge, Alan, let me address the chilling effect that the governor's actions have in fact created in this matter. I think that the governor has acted as a bully. I think he's acted inappropriately. And what did he tell the Commission on Judicial Conduct? He didn't ask for an investigation. He asked for a removal. And when does he want the removal? He wants the removal within 60 days. And what if he doesn't get the removal? Well, the Senate Majority Leader, Senator Bruno, has actually linked the funding of the Commission to the result that comes out of it.
Well, it's interesting that the Commission has lost...
Are you sure of that?
It was in the Times.
Well, the Commission has lost a lot of his funding and doesn't even have the money to pay their rent right now.
Correct.
But let
me just finish my point, Judge. The point is that now, as an advocate, as an attorney for the judge, I need to go before this commission that has been a gauntlet has been thrown down in front of this commission on threat of its own existence, not to do an investigation, but to remove. I mean, the governor has drawn his conclusion.
Yes, Judge.
But the governor, smart enough, said that in the event that the report gives him additional information or other information, he will not move ahead.
And how many people do you know?
But that's unfair. You see, that's
terribly
unfair because now a person's reputation, the judge's reputation, is prejudged, and that is unfair, especially for people who are in power. when you are an elected official, and power is something you should always use and never abuse. A governor, a mayor, a president,
Or a judge.
Can always get publicity, and it's always easy to say something against somebody. And what happens is later on, their reputation is destroyed, and that's where the problem
And it's
lies.
never given back.
And it's never given back. It's given
Correct.
back by a little squib on page 11
Correct.
somewhere that no one reads. And that is what is terrible here. If the governor felt that there should be an investigation, he's entitled to that.
Absolutely.
But
There's no
not
issue about that.
prejudging
When I-
Before a factual hearing.
That's correct.
And that's what he did by making those statements?
Obviously.
Well, he said he read the record.
Well, I
No.
don't really want to go into. I really don't want to go into the case itself because I don't think
Ron,
it'd
let
be
me ask you
appropriate.
this. In your opinion, does the Commission on Judicial Conduct, which the governor has asked to remove Lauren Duckman, Judge Duckman, do they have the jurisdiction to go into whether or not a judge's decision, if a judge acted within his own discretion?
Well, I certainly don't think that they do, but the complaint has been couched in somewhat different language.
Oh, I see.
The language that has been used by the governor is that because of this ruling, that the judge has exhibited an anti-prosecutorial bias. And it's that anti-prosecutorial...
Oh, he's a defendant, he's a defense
Correct,
lawyer.
correct.
He's a criminal lawyer.
And
He's for the
right,
criminal.
Right, and as you practice in the courts, I don't think that there is a judge who doesn't have a reputation one way or another of being pro-prosecution or pro-defense. I mean, it's something that I've certainly in 25
Well,
years...
isn't that
experienced
interesting? Because judges who are harsh, not necessarily fair, are considered by the public as being good judges.
Correct.
Judges that may be fair might be considered by the public as being bad judges.
Correct.
Now that's something really terrible if you really think about it. But those are the facts of life.
Do you agree with that? That's the public's perception?
Oh, absolutely.
I
And
don't
I
think
think
there's any issue
and I
that
think
it's
the
a public
public feels that judges leave defendants out. I mean, you have an example of the federal court in the Baer case, for example, and you have now with the new legislation to eliminate some of the rights of the
Well,
defendants.
you have
If
Judge
you-
Baer on one side and Judge Rothwachs on the other. Judge Rothwachs says we are giving the criminals too much leeway. Miranda should be
And
done away with.
no one's called for his removal.
But let me just tell you something interesting. If you were to do a survey to see how many cases there is suppression by judges, now I've been on the bench 5 years. I've handled hundreds, if not 1,000 cases, okay? Probably in 2 or 3 instances did I suppress the evidence because it was really outrageous. It should have been suppressed. In most judges throughout this state, if not in the country, there are few cases in which the evidence is suppressed because it was illegally obtained. So the feeling that because of this defendants get away with murder is not
Judge,
factually true.
Before you were ascended to the Supreme Court bench, you were a politician. You
I
were
was
the
a city councilman
for many, many years.
16 years.
And so you have really a look at both sides. You were in politics, and you know politics, and you know the judiciary. Is what is Governor Pataki doing? Is that politics?
Oh, absolutely. There's no question about it that it's politics.
Is he
And-
trying to gain favor?
Well,
From a certain segment of the population?
And the population is going to be with him. That's a tragedy.
Because
The
who
population-
stands by a judge?
That's not the reason. Because the public is frustrated. They are frustrated because there's a lot of crime out there, and they want to be able to blame someone or something for that crime, and they want to give a message. That was the death penalty. What was the death penalty about? It was the public out there saying, we don't like the crime. You know, I just looked at the statistics, interesting enough, of 1993, and I found that there was 273,000 arrests in 93, while in 95 there was 316,000, almost a 20% increase in the amount of arrests in New York City. So while politicians say that there is less crime,
And the FBI statistics say it as well.
it may be in categories.
But not overall as
But
far as
not
arrests.
overall, and so the public is right.
We'll continue this conversation right after the break. You're watching Lawline. I'm Alan Schnorman. Stay with us.
In a life-threatening emergency, you should know what to do. Say a loved one exhibits unusual symptoms. The first thing to do is... Clear! No. The first thing to do...
Oh! Tourniquet!
No! The first thing you do is pick up the phone and dial your emergency number.
Call 911 first.
Right.
How about mouth to mouth?
I don't think so. To learn more about life-saving techniques, contact your Red Cross.
Your approach is looking good, Cobra.
The men and women in the National Guard and Reserve face some tough challenges when they serve. Challenges that teach them discipline, leadership, and technical skills that make them better employees. So when they need time off to serve, don't make their toughest challenge approaching you.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today with us is Judge Abraham Gurgis of the Supreme Court and Ronald Russo. Mr. Russo is representing Judge Lauren Duckman. Ron, now, if the commission says Judge Duckman did everything right or they have no jurisdiction to rule on his decision, it goes to the state legislature. Tell us what's going to happen there.
Well, hopefully, as Judge Gurgis has suggested, that the governor has not painted himself into a corner. But if he has, and he's now going to force the issue in the Senate,
right.
My understanding of the process there, as inartful as it is, since it hasn't happened since 1872, is that there would be a full trial before the Senate, and the vote that would be required would be a two-thirds vote of the Senate. And my understanding of the count is that the governor would need 41 votes to impeach the judge. There are 37 Republicans. I would trust that they would not vote along party lines, but vote on the merits of this matter. And the issue in my mind is should it go that far, whether or not there aren't certain constitutional constraints on this sort of conduct that the courts should stop. My concern on the broader issue, I think that Judge Duckman is really just a lightning rod who's taking the heat at this point for an entire structure, which is the judiciary. As you know, Alan, I'm predominantly a federal practitioner. And somehow, 200 years ago, when the Founding Fathers formed the country, they knew that presidents should have 4 years, senators 6, representatives 2, and judges should sit for life. And I believe that the reason and the glory of the federal bench is that the men and women who sit on those benches need to be above these kinds of political winds. Do you really think that the country would be as desegregated as it is if the judges who signed the desegregation orders had to be concerned about the next appointment or the next election? Judges are there to form a balance in the criminal courts and the criminal process between the power of the state and the individual defendant. And as Judge Gurgis suggested a little earlier, that is something at this point that the public is having less and less patience with.
But Governor Pataki and actually Mayor Giuliani has both stated that they're taking this position because, in their opinion, Judge Duckman's conduct was outrageous.
Right. I've read the record. The conduct is not outrageous. The question might be, I'd ask Alan and I'd ask the judge, if someone is incarcerated on misdemeanor charges, how long would you hold that person?
That's, of course, a different issue.
Well, I don't know that it is.
It's an important issue.
It's a very important issue.
It's an important issue because when a judge now, you wouldn't want to appoint somebody as a judge and say, well, philosophically, this is what you have to do for you to be reappointed. See, in the Supreme Court where I sit, I'm elected, so it's a little different. But in criminal court, for example, or in family court,
Criminal courts appointed by
are
the
appointed
mayor.
by the mayor. And do you want to have somebody on the bench to say, well, in order for me to be reappointed, I better do what the mayor says?
There's little question that those people are thinking that
That
now.
is very dangerous when that occurs. And that is dangerous for the public because, as I said, judges are not supposed to be nice guys.
The New York Times has reported that, at least in their survey, many judges, or at least some judges, are now ruling more harsher than taking the easier way, but this is actually affecting their opinions.
Well, you see,
What's
it's a
your opinion on
question of
that?
whether, I believe it's probably so. It's probably more so in the criminal court because in the criminal court, you get the person in there in the first instance. You've got to set bail. I mean, a judge, for example, in criminal court might have 80 cases in front of him that day. He has to listen to 80 cases and make 80 decisions. Are they all going to be correct? Absolutely not. Is there any profession that you could think of that has an appellate court look over what you're doing, except for judges, really? There aren't. So judges are human. They gather the information that is given to them, they make a decision. And they're going to make some good decisions and they're going to make some bad decisions. But they're going to make an informed decision usually. And usually what happens when you really look into the nitty-gritty of it is somebody did not give the information on a specific case.
Well, that's certainly the record in the Duckman matter. Right?
And usually that will occur, but the public doesn't want to hear from that, understandably. An elected official or somebody who wants publicity grabs that, okay, and runs with it and misinforms the public. That is really where the problem is, that it's misinforming the public. And when you really start digging down, then you find that, in effect, usually judges make the right decision for the information that they have before them.
Ron, why did Judge Duckman reduce the bail, allowing Mr. Oliver to leave the jail?
I think that the reason was that, remember what he did. All he did was reinstate the bail that was initially set a month earlier or 40 days earlier. Bail had been set at $2,000.
Why did he do it?
Because the DA was told on January 2nd to be ready for trial on January 9th, and they weren't ready. They were told on January 9th to be ready on January 23rd, and they weren't ready. Look at the record. The ADA is asked, are you ready for trial? We're not. The judge's view of it, and I think it's the accurate view, is that a citizen who is accused of a crime is entitled to liberty pending trial. We don't incarcerate people in our society, at least we never have, and throw the key away while trial is pending. Even in a murder case, you're entitled to reasonable bail. And as you may know, Alan, the sole purpose of bail is to secure a defendant's return. Preventive detention does not exist in New York State. The judge merely applied the law as it existed at the day that this man was before him. And was he right in exercising that discretion? He was released, Oliver was released on January 24th. He was told to come back the next day. He did. And the first thing the judge said, asked the ADA, I want you to call Ms. Komar. Has there been any contact? Judge, we've been in touch with her. There hasn't been any. I want you back here tomorrow, Mr. Oliver. He returned again on the 26th. He asked again, has there been any contact? There has been none. I want you back in 4 days. January 30th, he returned, and Judge Duckman went through the entire process. He then asked the ADA, when do you want to go to trial? You know what the ADA said? February 28th. There was no rush to bring this matter to trial. The matter was put over for a month. 12 days later, on February 12th, this individual went out and tragically murdered Ms. Komar and took his own life. And it's really unseemly then for the DA to come forward and say, this man should have never been released. One of the quotes that Judge Duckman, that's attributed to Judge Duckman, which I think is what the law is, if this case is important enough for jail, it's important enough to be ready for trial. It was a half-a-day trial. Why couldn't it be brought to trial? This issue would never have arisen. Why is no one asking the district attorney why he couldn't bring the misdemeanor trial to trial in 40 days?
Well, let me just say this. Judges use different tools to accomplish what they have to accomplish at times. For example, and this goes into what you're saying, if a district attorney, and district attorneys very often have so many cases, and I feel terrible for them because they can't really try all the cases that they have. If a district attorney comes into my courthouse and I want to try a case today, and we're supposed to try the case today, the only thing that I have to be able to say, look, if you don't try the case within X amount of time, I'm going to have to release the defendant. Okay, I've given you warning.
Really? You mean dismiss the charges?
Not dismiss the charges, but he can't be sitting in jail for a period of time
based upon
when
the
people
district attorney's
not being ready.
That's exactly what happened
Not being ready
here.
within a specific amount of time.
What is the rule 30-30? 30-30, you get a release in 30 days on a misdemeanor. Isn't that what 30-30 requires?
30-30 is that if the people are not ready to try the case within a certain period of time, the case will be dismissed.
30 days for misdemeanor.
Well, I'm not
Let's not
familiar
get
with
into
but the important thing is that a judge uses that as a tool, because if you don't, then the DAs will never try their cases. So usually when you threaten the DA, you say, look, this fellow has been in now for 6 months, okay? We have the trial set and we've adjourned the case now 5 times. I'm not going to adjourn the case anymore. So you must be able to use those tools in a very intelligent manner to be able to make sure that justice prevails. I mean, you have to protect the rights of both the district attorney and the defendant as well.
That's an unpopular
it's
position,
a
Judge.
balancing of both sides. That is what the danger is and the chill on the judiciary. That, as I said earlier, you're not supposed to be popular. You don't have to have defendants like you, and you don't have to have district attorneys like you, and you don't have to have governors like you or mayors like
Judge,
you.
what is the judiciary doing? Are they sending a letter to the governor saying, hey, wait a minute, you're really going into an area that you should not be going into? Are they trying to contact them and say, hey, look, listen, you're back off a little because maybe it's within the discretion of the court and you're chilling the entire atmosphere here?
Well, I think Judge Kay has spoken out, who's the chief judge of our Court of Appeals, and the chief administrative judge. She has spoken out and said, let this go through a process. But there's certainly, she has said there's been a chilling effect on the judiciary on doing this, because you want a judge to be fair. And if there is pressure on him, whatever that pressure may be, that is unfair pressure on him, by saying to the judge, if you don't do what I tell you to do, if you don't make high bail, for example, I'm not going to reappoint you. Do you want a judge like that sitting on the bench? The opposite side, do you want somebody who says, look, if you do high bail or low bail, we're not going to have you there? So you want a judge that can be independent to give a fair and impartial hearing to whoever's in front of
Let's
him.
play this out if we can. Let's assume the Commission on Judicial Conduct takes no action. They say it's within his discretion, or we have no jurisdiction when a judge makes an opinion and we don't look into whether the opinion is good or bad. That's not what we're here for. And then it goes to the state Senate and a trial's had, and they find and they impeach him. Can then it go back to the judiciary and they find that what the legislature did was arbitrary and capricious and set it aside?
That could be interesting. I don't think there's been any precedent for that.
It's absolutely everything we see in this case is we're in uncharted waters. Whether or not it's an unconstitutional act on their part, whether or not it's an interference between the separation of powers, we don't know the answers to those questions.
But
I don't believe it's
I'll tell
litigated.
you, I think that if the commission finds that in any instance that there was really nothing wrong, I think that you're going to see the people backing off.
Oh, I see. In other words, you don't think it's really going to go to the legislature?
I don't think it will, because I think that sanity then will prevail.
Would you have ever thought, Judge, that the governor would have called a press conference in the middle of a day to seek the removal of a judge? I was stunned when I heard that that was happening.
You know, I think it's shooting from the hip. I think that everybody, and I know Judge Duckman as well, felt terrible of what occurred. I know myself, when I have to think of something and I think I might have made a mistake or I had a misjudgment.
Well, you had to do
I would
something
feel
that
terrible.
brought those
I
effects.
think politicians, and this is really what you were talking about, really go from the hip. And here you had somebody who was killed, who was left out, and therefore it's the judge's fault.
No.
And let's get the judge.
Judge Abraham Gurgis, thank you for appearing on Law Line. Ron Russo,
Pleasure, Alan. Always
thank
a
you
pleasure
again
being here.
for appearing on Law Line, the attorney for Judge Duckman. And as always, this is Alan Schnorman, and thank you for watching Law Line.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111.
This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.